So a judge in the case for the Charlie Kirk murder suspect ruling to release a transcript from the earlier hearing that was sealed into now. And it could be a sign of what to expect for a decision on whether cameras will be allowed in court.
Hello, my wonderful audience. This is Joseph, speaking directly to you. A warm and heartfelt welcome to everyone who is listening today. We stand together at the very beginning of a new year, 2026. This is a significant moment. First, let us offer our humble and sincere gratitude to all of you whom God has sustained, whose strength and faith have carried you from the last year into this fresh chapter. I say a happy and blessed new year. You are here, and that is a gift. But our hearts must also hold space for remembrance. With great respect and love, we humbly salute those who did not make this journey with us. To the families and friends who feel that absence, we share in your loss. May the souls of all who passed away last year find perfect and eternal peace. They are not forgotten. Now let us turn our attention forward together. The story begins not with a bang, but with a quiet legal decision. In a high-profile case that had been shrouded in silence, a judge made a simple move. He ordered the release of a document, a transcript from a hearing that the public had never seen. This small act was like a key turning in a lock. It signaled a shift. For weeks, people could only guess and argue about what was happening in the courtroom regarding a serious crime. Now, there was a promise of light. This case involves the death of a well-known commentator, Charlie Kirk. The evidence against the accused man, Tyler Robinson, is described by many legal experts as very strong. There are reported text messages, a confession to his parents, and forensic links. Because of this, the central question in the trial is changing. It is less about whether he is guilty or not guilty. The real battle, it seems, will be about the consequence. This is a death penalty case. The fight will be for life. The judge's decision to release the transcript was the first hint. The next bigger step is about cameras. The judge strongly suggested that the trial itself would be televised. His reasoning goes back to the very foundation of American justice. The Sixth Amendment guarantees a public trial. In the 1700s, that meant the public could sit in the courtroom. In 2026, it means the public might watch from their living rooms. The judge believes this is necessary. He argued that in a case where the entire nation is interested, the audience should not be limited to the few people who can fit into a courtroom. He said letting everyone see the trial for themselves builds trust. It allows the real facts from the courtroom to fight against the misinformation and wild conspiracy theories that spread online. But this idea of cameras everywhere is where the tension in our story grows. The defense team for Tyler Robinson is firmly against it. They have a powerful argument. They point to their client's demeanor. In his few brief court appearances, observers have noted that Tyler Robinson sometimes smirks or smiles. To his lawyers, this is a major problem. If millions of people see that smirk on their TV screens, they might decide he is guilty and heartless long before the jury hears all the evidence. That public opinion could, in some way, influence the world around the trial. It could also be a point for an appeal later. A claim that he could not get a fair trial because the whole country had already judged him. So, we have two powerful forces facing each other. On one side, the principle of public transparency, of a nation seeing its justice system work. On the other hand, the right of one man to a fair trial, untouched by public fury. The judge is trying to find a balance. He has set strict rules for the cameras. They will be allowed, but they will not show everything. The camera will not show the restraints on Tyler Robinson's wrists or ankles. He will be dressed in normal clothes, not a jail uniform. The goal is to show the trial, not to create a dramatic spectacle. But the question remains, can you control how people feel about what they see? Outside the courtroom, the country is deeply divided. On social media, the debate rages. Hashtags like hashtag Justice for Charlie and hashtag Open Courts clash with hashtag Fair Trial and hashtag Prejudicial Media. For some, televising the trial is a duty, a way to honor transparency. For others, it is a dangerous step that turns a serious legal process into reality TV. The memory of Charlie Kirk is claimed by different groups, each with their own idea of what justice for him should look like. This brings us to the heart of the mystery in this story. With such strong evidence, what is the defense's real goal? Legal experts watching the case suggest the goal is not an acquittal. The goal is to save Tyler Robinson's life. The trial will have two parts. First, the verdict, guilty or not guilty. Second, if he is found guilty, the penalty phase, life in prison or death. The defense strategy, therefore, is focused entirely on that second part. Every move is about keeping the death penalty off the table. Their fight against cameras is part of that. Their careful arguments are part of that. There is even a historical precedent for this kind of strategy. The famous defense lawyer Clarence Darrow once faced a similar situation in a case called Leopold and Loeb. The evidence was overwhelming. So, Darrow did a surprising thing. He had his clients plead guilty. This skipped the verdict trial entirely. It moved the fight straight to the penalty phase, where Darrow could use all his skill to argue against the death sentence. He succeeded. Could this happen here? It is a distinct possibility. A guilty plea, even at the last minute, is not out of the question. It would not be an admission for forgiveness, but a cold, strategic move. A move to control the battlefield and fight the only battle the defense thinks it can win, the battle against execution. This possibility changes how we see everything. It makes the defense's actions look less like a claim of innocence and more like a life-saving mission. It makes the prosecutor's job about proving not just guilt, but that the crime deserves the ultimate punishment. And so, as 2026 begins, the nation waits. We are waiting for a trial that will be about more than one crime. It will be a test. A test of how we seek justice in the age of cameras and instant judgment. A test of how we balance the public's right to know with the defendant's right to fairness. The evidence seems to point one way, but the human story, of strategy, of life and death, of a nation watching, is only just beginning. The gavel is ready to fall. The cameras are ready to roll. We will all see what happens next.